is a supreme Second Amendment attorney, and he's also one of the attorneys on the Miller versus Bonta case, which is the lawsuit against California for their assault weapons ban, which is little more than it's a gun ban. It's not that's all it is. Assault weapon is just a pejorative term. So there's a lot of information I want to get to, including I want to play a clip from one of the attorneys because this case was just in court. So without further ado, John Dillon.
Hey, buddy.
How's it going, guys?
Fantastic.
Did you get the Tesla truck?
No, I did do that $100 deposit for him, but I haven't heard anything, from Tesla for 3 years.
Don't you listen to me? Did we not have this talk?
Should have done it. Okay, so SB2. The assault weapons ban was in the courtroom last week, and I wanted to bring you on so they could hear it from the horse's mouth. What exactly happened, my friend?
Yeah, so just a little bit of background. We got another favorable decision from the district court in the case back in October. And of course, the court ruled that the ban is wholly unconstitutional and that it has no historically analogous regulations that could support it. And so they struck it down, but the state appealed in a somewhat surprising fashion. The Ninth Circuit expedited the appeal, so we got briefing done all through December. And we had our oral arguments on appeal this last Wednesday up in Pasadena. And so we got to go into court and make the oral arguments. And that was the first time we sat in front of this three-judge panel and, made our case.
And so give us the highlights. So I do want to play a clip I actually have a clip from what the state's attorney talked about, a very interesting exchange that I wanted to hear your thoughts on. But before we even get there, so it was in front of a three-judge panel. Each side, the attorneys got to make the case, sum up kind of what happened, like what did you guys say, what did the state say, and then what was the result?
Yeah, so it's interesting. So because the state was the one appealing the lower court decision, they got to go first, and they essentially said, "Well, hey, look, the Supreme Court in Heller it said handgun bans aren't constitutional, and then Bruin also said there's no balancing of interests, and that we have to use historically analogous regulations, but that's not really what they said. They're much broader than what you're reading in these decisions. They actually aren't so regulative, and it's what guns are most useful for self-defense purposes. Those are the guns that we can't ban. Only the ones that are most useful for self-defense, and the state adds in all these new conditions and modifiers in order to, try to regulate the, very clear decisions that have come out of the Supreme Court to justify their ban. So basically, they're trying to make the claim that the Supreme Court has said that, you can, the only guns you can't ban are the ones that are mostly used and actually used for self-defense. Not for any lawful purpose like what was said in these cases, but for, we can only, handguns, since they're the quintessential self-defense firearm, we can't ban those, but we can essentially ban everything else. That's kind of their overarching theme when it comes to their argument.
And really what you guys did, is it fair to say that you just brought up Bruin? You just leaned back on, hey, here's what they said during Heller, here's what they said during Bruin. I mean, it was basically the Miller side, the pro-Second Amendment side, was just reminding the three judges, hey, guys, the Supreme Court's already ruled on this basically twice, and it's in our favor.
Mm-hmm. Yeah, and that's the thing. It's not like the Bruin decision wasn't clear. It was very clear. Anyone can pick it up, read it, and you don't need a law degree to understand what it says. And so we quite literally, we're just quoting the Supreme Court. We're quoting the controlling authority of the entire court system, the entire justice system. And, so our argument is very straightforward. The fact is that, these semi-automatic firearms, they're not dangerous and unusual because they are in common use throughout the country, and because they are in common use, they can't be banned. That's about it.
Okay, I'm gonna play that clip from this is the state's attorney trying to make the case to the 3-judge panel. So go ahead and Brendan, play that clip.
So your position is that this would be, these kinds of weapons would be outside the original public meaning of what a bearable arm is.
That's correct, Your Honor, because these are military weapons. These are not weapons of ordinary self-defense.
But when we look at Heller, right, so it starts with, they've got, Dr. Johnson and some of the other 18th century dictionaries that just define arms as weapons, right, which these clearly are. And in Heller, it was common ground that everybody agreed that it at least applied to weapons you would use in militia service, and then the question was, does it also apply to other kinds of weapons? As I read Heller, there wasn't really any question that weapons that would be used by people in the military would count as arms. Was there?
So at the founding in 1791, when the Second Amendment was ratified, the Supreme Court observed in Heller that the same weapons that were commonly kept at home for ordinary purposes like self-defense, those were the same types of weapons that militiamen brought to muster. But over time, because of technological advancement, certain weapons have fallen outside of the scope of the.
So basically the state's saying, hey, but the technology changed, so therefore, we get to ban guns that are ugly. Is that did I sum it up pretty perfectly?
Essentially, that's what they're saying. They're saying that we had muskets back then, but we don't have muskets now, so we can ban these. And what he's essentially saying there is that these semi-automatic firearms are not arms. So which is
ridiculous.
It's a ridiculous thing to even say. It's very clear, and that's what the Judge Miller was kind of hinting at strongly with those questions. He's like, look, to determine whether something is an arm, you look at the plain text. Okay, Second Amendment protects the right to keep and bear arms. Okay, what is an arm? It's any weapon used for offense and defense. That's a very simple thing. That's not a debatable subject, but you see in these situations that the only chance that states like California have in sidestepping the Constitution is to try to make absurd arguments that no, these firearms aren't really arms, even though they are, but they're not. Like don't use common sense and ignore that.
Which is weird because out of one side of their mouth they're saying that, and out of the other side of their mouth they're saying, well, they're just for military use. They were designed for military use, and then they're saying, but they're not really arms. Come on. They're really grasping at straws here. Okay, so we have like 2.5 minutes. So a lot of back and forth. I think that if you didn't listen to the video, you can see it online. You can hear it. I think it's well worth listening to, so you know what they're trying to say, and you can hear, of course, the truth from our side. But what was the result? So where are we now? Have they come back with a decision, or what does it look like now?
Yeah, so this is what happened. This is something that I predicted about 3 minutes into oral argument. I kind of saw this coming. And anyone who listened to the oral argument knows that, some of the first questions that literally all three of the judges on the panel asked about was the Duncan case, which is a challenge to the California's ban on high-capacity magazines. Now, the court, basically they're saying, well, shouldn't we just wait till the Duncan case is decided because that's about to be heard en banc by the 11-judge panel in California. And they're like, well, there's a lot of the similar legal questions and theories that, are going to be answered in that we got to answer in this case. So shouldn't we be waiting? And, after hearing those questions come, right at the beginning of the oral arguments on both sides, I figured that was going to happen, and it did. The court actually issued an order that stayed this case until pending the decision in Duncan. So they put a pause on our appeal.
The Miller case is being paused until there's a decision in the Duncan case, and then the decision in the Duncan case will be applied to the Miller case.
Yes. So whatever analytical reasoning that's used in the Duncan case is going to likely be applied.
Now, is that it, or is there anything that can be done here, or no? We absolutely have to wait for the Duncan case now.
On this appeal, we're waiting for the Duncan case.
Okay. All right, John. Thank you, man. Thank you so much, John Dillon, Second Amendment attorney extraordinaire, right here in San Diego. Thank you for all that you do, John. Really appreciate you, man.
Thanks for watching this clip from Gun Owners Radio. If you're watching mainstream media, you're not getting the truth about guns. Gun Owners Radio is the easiest way to stay on top of the Second Amendment fight, the fight for your self-defense rights. You can watch our live stream on YouTube every Sunday from 4 to 6 p.m. California time, or if you're in San Diego, AM 1170, FM 96.1, The Answer. We're also available on your favorite podcast platform. Just search Gun Owners Radio and you'll find our show. Like and subscribe to help defend and restore the Second Amendment, not just in California, but across the country.